judiciary plays a very important role within the UK constitutional system. It's their job to see that the rules or laws are enforced. And that's part of an important concept in any democratic system called the rule of law. Rule of law has a lot of different interpretations placed upon it, but a central feature of it is the idea that everybody within a society, including those who govern us as well as those who are governed, are subject to the law. They're subject to a consistent set of rules that are impartially enforced. And that's where the judiciary, the court system, comes in. It's there to interpret those rules and to make sure that everybody abides by them. When we think about the UK constitutional system and the UK system of government, particularly important to take into account the way in which that principle applies to the governors, in particular to the government or the executive, the ministers and the civil servants who advise them, because it's very important that they are subject to rules, that they have power, but that power is exercised subject to the law, that they don't have unlimited discretionary or arbitrary power. They can't just do anything they want. Otherwise, there's always a threat that that power could be abused, for instance, for financial gain or to take away people's rights. Various other forms of abuse are possible. So that it's very important that the courts have a power to ensure that ministers and the officials working for them are always acting within the law, that are adhering to the same rules that apply to everybody else. And that's where a thing called judicial review comes into play. This means, according to judicial review, courts are able to scrutinise the activities of government and judge whether they were within the law, whether the government behaved reasonably, whether it behaved in a way which was in accordance with what we could reasonably expect them to do, and also whether the powers they use actually exist, whether they actually have the legal power to do the things they're doing. Courts, as we've talked about in another video, can also scrutinise the acts of government from the point of view of human rights and ask, have they abused human rights? So the courts have this ability to carry out what we call judicial review. While there's wide acceptance that courts should be able to do this, there is a bit of an argument about whether over recent decades the courts have taken on too much power, that they've actually overreached themselves and they've come to start interfering in the business of politicians, of democratically accountable politicians, and whether they're in fact overstepping the mark, interfering too much. There have been various controversial cases and various complaints about the idea that courts are actually becoming political, that they're second guessing the actions of ministers and they're applying their own values rather than simply assessing whether the law has been adhered to. The counter argument to this is that the business of government has become increasingly complex, that it's quite difficult for Parliament continually to oversee what the government's doing all by itself, that there's always going to be a real need for courts to be able to hold government to account against the law, to make sure that governments are remaining within the law. Therefore, those who defend judicial review say there's not a problem with it, argue that actually the courts aren't overstepping the mark and they're performing their proper role, and in fact government and Parliament has asked them to perform this role by passing legislation such as in particular the Human Rights Act 1998. So there's an argument going on there, and sometimes governments bring forward proposals, or parties or different politicians make proposals to restrict the scope of judicial review, sometimes to pass what are called ouster clauses, which are designed to stop the courts from scrutinising some activities of government at all. Another part of this argument is the limitations on the judiciary in overseeing government and overseeing public authorities. While the debate is often about whether or not the judiciary have become too powerful, and another question is, are they powerful enough? And this takes us into the debate about the nature of the UK Constitution. Because in many other systems where we have what are called written or codified constitutions, it's possible for a court to strike down the acts of public authorities and even to annul primary legislation, equivalent of acts of parliament, on a basis that it conflicts with the constitution. In the UK, we don't have a written or codified constitution quite like that. Therefore, the courts do not have that power to strike down acts of public authorities or strike down primary legislation, acts of parliament, on a basis that they are unconstitutional. In fact, a court cannot strike down an act of parliament at all. There was a period when the UK was a member of what became the European Union, so between 1973 and the beginning of 2020, there was a period when courts had this power. Courts could strike down primary legislation if it conflicted with European law, not if it was strictly unconstitutional, but if it conflicted with European law. But now we've left the European Union, that power doesn't exist any longer, and a court cannot strike down an act of parliament. So although half of the debate about the role of the judiciary in our constitutional system is about whether the courts become too powerful, there's another aspect that some might argue they are not powerful enough because we don't have a written or codified constitution.